can't be prejudiced by introduction of a document that you knew existed. And you already found in the spoliation order that as of December of 2021, Mr. Young knew he was going to be bringing this lawsuit or was contemplating it. You can't get around your discovery obligations by signing a document, then sending it off and saying, I no longer have it, can't produce it. That's what happened here. I mean, he got the contract.
I sign a document, send it off. It's within the company's possession, custody, or control. What is my discovery obligation to go to their records, dig through their files, and find a copy of a document I signed several years ago?
But that's not what I was suggesting, Your Honor.
It was. You said he can't shirk his discovery responsibilities by signing a document, sending it off, and then say, I don't have it.
He had it, is what I'm saying.
I get the court reporter to read back exactly what you said, but I think I verbatim said exactly what you said.
Your Honor, the point
I'm tired of these blatant misrepresentations that are being made, and they're being made by both of you. And maybe they're not 100% lies, maybe they're leaving out a little bit of the truth in making representations, so you can carefully say, well, I didn't exactly say that. But you said he's lied to it because he doesn't have any work, but he had no proof that he had work because you're arguing that he signed a security agreement so they could hold his security clearance. But I didn't lie and say he had work. All right, we're taking a break. I'm going to go read this real quick. Let me ask you one last question, Mr. Axelrod. You said, we were going to call Helios Global or whoever it was from there as a potential rebuttal witness, and that's why we served a subpoena. We didn't need to list a rebuttal witness on our exhibit list. But you also had production of documents from non-parties. And I remember reading 2 motions to quash that verbatim said Rule 1.351 expressly provides the rule that is the exclusive procedure, in quotes, the open quote, exclusive procedure, close quote, for obtaining documents from non-parties without a deposition. Your subpoena for trial to whomever at Helios had a production request. The motion also says that the motions that I remember reading said that 1.351 requires the notice to the other side. How are you not conducting discovery pursuant to 1.351 in sending a subpoena ducis tecum to Helios Global without giving notice to the other side?
We need to send notice of this to the other side. I told her that was a witness subpoena in 38 years. I've never served copies of witness subpoenas to the other side and don't recall getting copies of witness subpoenas. I was looking at it as a witness subpoena, not a document production request. There was a ducis tecum component to it. I don't recall seeing it, but it was there, and I think, I'm responsible for that. So if the rule requires notice of a witness subpoena that has a document production request to it, that's on me, and I take responsibility for that.
Well, and Mr. Axelrod made the representation that fortuitously we ended up just falling into our lap at the last minute. But it wasn't fortuitous because it was pursuant to that witness subpoena.
That is true. Mr. McManus did send it, but we didn't want him to come testify. That is correct.
All right, I'm going to go look at this. I'll be back. All right, I went back through and I was reading the trial transcript that preceded the sidebar and then adjourning with the jury and the discussions that we had with the Helios document that was handed, 589? I think defense 589 was the document that was handed to Mr. Young during the cross-examination. I think I made comments throughout the course of this case about how counsel was conducting themselves, how everything was a surprise, a last-minute thing, how counsel was referring to each other in the course of their arguments, had to impose a $100 fine. I find it rich that we've got discovery being done at the same time a motion to quash is being filed, arguing that the plaintiffs are violating the rules by sending out trial subpoenas when the defense is doing the exact same thing. Representations being made to the court that we were just fortuitous to get this. It wasn't fortuitous. It was you were doing the same thing that the plaintiffs were doing and sending a trial subpoena for documents without notice to the other side in violation of Rule 1.351 that y'all cited in a couple motions, and just saying that this showed up in our lap. Represent to me this morning, we didn't accuse him of having anything beyond a security agreement, but that was clearly the implication that was being made when we were arguing about the document because you wanted to impeach him with it, despite the fact he admitted to signing a security doc. Then you changed it, we want to use it substantively, and it got admitted into evidence. And it was admitted into evidence under my Binger analysis of something that, there's not prejudice to the other side, was primarily the reason. Had I known it been discovery being conducted after the deadline, there was no way in hell that the document would have been admitted into evidence. Mr. Axelrod, I don't know how many times in this transcript, I didn't bring a piece of paper back with me, how many times you called Mr. Young a liar. But yet in his deposition, he acknowledged having his security being held by Helios Global, which is exactly what that document is and which was exactly what he testified to. I think an apology from you was clearly in order, Mr. Young, for the number of times in front of this court and streamed around the world that you call Mr. Young a liar for failing to disclose a document that you have no proof was within his possession, custody, or control. You know, everybody here, I don't know how much money we're clicking off an hour in lawyer bills in this case, and how much credentials the lawyers have in this case. The case has been pending for 2.5 years in my court, and I made a joke, looking back through this transcript, I made a joke of you only have a week and a half to do more discovery in this case till we finish up the trial, but it seems like everybody wanted to do everything at the last minute without telling the other side that we're going to do this discovery and then accuse the other person of being the bad person. And I said in this transcript, I'm not going to decide the case based on who can sling the most mud at each other and make each other look out to be the worst person. It came up in the course of things. This isn't kindergarten. Y'all matriculated from kindergarten a long, long, long time ago. Or at least that's what it says because y'all have bar licenses. I'm troubled by all of this that happened. The easiest thing and the clear thing I'm doing is I'm permitting you to call Mr. Conway and get him here to testify and rebuttal. But I'm overly concerned with the level of professionalism or lack thereof that's here. I'm overly concerned. I mean, the transcript of what I read, we said at sidebar when we were arguing after we excused the jury, conflicts Mr. Axelrod with the argument you made today to me. The argument you were making when we were arguing about the document last week, you were suggesting that, oh, we got the smoking gun, this is the crucial document in our case. I don't know how many times I've heard that from both sides in this case. Or the crucial witness. Like every document, the thousands of documents we have in evidence in this case are the crucial documents. But this was being represented as, oh, this just fell out of the sky in our lab, not that we were doing the same thing we're accusing them of being bad people to do. And I take that as a complete insult to me as the court in this case. And you were saying that he completely lied and misrepresented despite the fact he acknowledged that he had a security clearance level, which again is another misrepresentation of the court which supports the argument that you were being made. So right now your credibility with me, Mr. Axelrod, is about none, if you understand that.
I do. I certainly do, and I apologize when you feel that way. I apologize if you feel that I've misled you. That certainly wasn't my intention.
Yeah, well, you said, oh, I never said that. Well, no, you did. So today you said I never said that, but that's what the transcript from last week was representing. I'm reserving on any other sanctions pertaining to this matter and other matters against lawyers and parties in this case, but at least to resolve the issue for this morning to go forward, you can get Mr. Conway here, and I'll do this too. If Mr. Conway cannot make it here, we can call him via Zoom.
Thank you.
All right? Is there anything else we need to get before we get the jurors in here? And let me say this. I mean, y'all made a lawyer like that in Philly or New York or D.C. or wherever the heck it is, or Miami. We don't lawyer like this around here. Y'all may have handled some big cases. We're not going to play the shenanigans anymore in this case. Y'all both understand that? And I'm upping the fine for personal insults to $1,000 per time from $100.